Good morning. This is the Colorado Energy and Carbon Management Commission. This is our weekly meeting. It is Wednesday, February 19th. It is 9 o'clock in the morning, and we will start with a roll call.
Thank you, Commissioner Ackerman,
Here.
Commissioner Cross,
Present.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have four commissioners present.
Great. That is a quorum. Commissioner Oath is out of office this week and hope she's doing something fun. Today we have a presentation on Class 6 primacy, not Class 4. The agenda was a little numerically challenged. We also have a consent agenda, and we have one oil and gas development plan, which is a continued matter from a previous docket. Before we move into that agenda, we are going to move to commissioner comments. And commissioners, if you're comfortable with it, I'd like to recognize Kristen Kemp, our community relations person. Kristen, I don't actually know your complete title. If you could clarify, that would be great because I think you've got some exciting news for us.
Yes, thank you, Commissioner Robbins. Good morning, I'm Kristen Kemp. I'm the PIO and Community Relations Manager, although titles don't matter much. So thank you. I am here this morning to provide an update on our Environmental Justice Liaison recruitment. And I am thrilled to say that this will be the last required update because I can announce who the folks are who are joining us. I can say that Steve Arauza from Rifle, Colorado, and Jessica Chavez of Denver will be our agency's first ever environmental justice liaisons. So in these roles, they'll serve as dedicated resources to disproportionately impacted communities. And you all are well aware of the background of these positions. And we're just floored by the quantity and quality of the competitive recruitment. We recruited heavily, and Steve and Jessica absolutely rose to the top. And so if you would like, I am happy to describe a little bit about their roles or about them, or I can come back at another time and introduce them, which I would love to do.
Why don't you give us just a short synopsis of who each of the individuals are, and then yes, I think we would love once they're on board to set aside 30 minutes or something at a public meeting and have a formal understanding and introduction. But just a little more so that we can give some context.
Yeah. So you well know the cumulative impacts rules were adopted by you in October and went into effect in December. So these positions in particular are part of that rulemaking, and they really codify the ways in which ECMC can expand upon our existing environmental justice best practices internally as an agency, and then very much externally as we hold operators accountable to the new outreach engagement requirements as part of the rules. So I feel grateful to folks, our stakeholders who participated in the rulemaking, particularly Green Latinos, Conservation Colorado, for their advocacy of these roles. So Steve will be our West Slope liaison, and as the name implies, his geographic territory will be disproportionately impacted communities in the West Slope, and also he'll be our tribal nations liaison. And then Jessica will be our EJ liaison for the Front Range, and then also for Hispanic communities statewide. So in their roles, they will proactively engage with disproportionately impacted communities, with operators and their newly required engagement plans. And yeah, really thrilled. You all, I think, hopefully already know Steve. He has been at ECMC for almost a decade as an environmental specialist. He's a geologist by education, absolutely familiar with the oil and gas industry on the West Slope, and also a Chicano environmental justice advocate. And really ideal for this role. And likewise, Jessica, a decade of environmental justice work. Um, she was a Keystone Fellow, worked at ELK, Environmental Learning for Kids. Most recently, she was an Environmental Justice Fellow at Yale. So we, uh, I think we got unicorns. They are just ideal. And I feel very humbled and honored to get to work with them as we stand up this EJ program. And I'm really eager to come back, like Commissioner Robbins says, maybe in a couple of months and describe more our strategy for EJ outreach.
Uh, Fantastic, tremendous news. Thanks for the update. Really appreciate that, Ms. Kemp. And yeah, I think we'd look forward to seeing you and the community liaisons at a meeting in the future once you feel that it's appropriate and the timing is right. So keep us posted. Does anyone have questions? All right, seeing no questions, we'll let you move forward with your day. Thanks again for joining us this morning.
Thank you.
All right, commissioners, any further comments? Seeing none, moving to consent agenda. Does anyone have questions on consent? Seeing none, I would move approval of the consent.
Second.
Motion and a second. Further discussion? Seeing none, all those in favor signify by saying aye. Aye. Motion carries. Are there any noes? No. Okay. Moving along, we will move to our Class 6 primacy application presentation. And I believe we've got Mr. Seeley.
Thank you very much. I will share my screen. Can everybody see this?
We can see it, but you are very, very soft-spoken. If you could maybe turn up your mic or get closer to it.
Okay, that sounds good. I can definitely raise my voice and turn up my mic. Okay. Is this better? Or
Yes.
am I still low?
You could get a little bit higher in volume, that'd be fine.
Okay, try something else. How about this? Does this sound better?
Yeah.
Okay, great. Well, good morning, commissioners, and thank you for having me. My name is Mark Seeley. I'm the lead CCS specialist with the Colorado Energy and Carbon Management Commission. Before we get started, I just would like to take the opportunity to thank everyone who has contributed to the state's effort in pursuing primacy over Class 6 UIC wells. This includes our stakeholders, our partners at various Colorado agencies, such as CDPHE, Colorado Energy Office, the Attorney General's Office, Department of Water Resources, and many external professionals from other state CCS or UIC programs. And a special thank you goes out to the internal ECMC staff, whose great work has been important in this endeavor. Specifically, I want to express my gratitude to Lauren Mercer-Gelman and Ben Boudreau from our AG's office, as well as Mike Rigby, Kat Campbell, Marie Horner, and Alex Axe, whose contribution in putting this draft application together has just been essential. Thank you all for your hard work and commitment in moving this forward. The intent of today's presentation is to publicly present our draft Class 6 primacy application, which you guys know marks an important milestone in our ongoing efforts to secure regulatory authority over carbon storage wells. I will review the key components of the application and outline next steps in the process and how interested parties can submit public comments on the application. Many of you are familiar with the timeline that outlines the primacy work conducted by the state, leading us to this point that we are at today. But just to quickly recap, this effort began in 2021, and through a series of work groups, reports, legislation, and collaborative efforts with our stakeholders, led to the Class 6 rulemaking last year. The final step in the process to obtain regulatory authority is to submit our primacy application to the EPA and obtain its approval. Today marks the first step in that process, as the draft primacy application will be made available for public review and comment. I will outline at the end of this presentation how the application can be obtained and how comments can be submitted. Moving on to the application components, there are two different categories of requirements that must be addressed: state requirements and federal requirements. The Colorado requirements originate from SB 23016. These include the Commission holding a public hearing on the matter, which this hearing and the next hearing will satisfy, and both the Governor and the Commission affirming that the state has the necessary resources to ensure the safe and effective regulation of Class 6 wells. The federal requirements involve the following key elements: a governor's letter, a program description, an attorney general statement, a memorandum of agreement, all applicable state statutes and regulations, including the crosswalk, and compliance with public participation. And I'll briefly outline each of these in the next couple of slides. So the program description is where the bulk of the material can be found. And if people are going to spend time reviewing our application, we really recommend this as one of the key areas to focus on. While it doesn't cover every aspect of our 1400 series rules, it addresses the main components, such as the state program scope, structure and processes, the organizational structure, staff, estimated costs and funding for the program. And it also outlines the permitting process and describes the program forms that will be used to administer the program. Additionally, the program description includes estimates of industry activity expected to occur within the first 2 years of program approval. And finally, it addresses notification procedures as well as transboundary notification or coordination with neighboring states and jurisdiction. Now let's walk through the other federal requirements. First, we have the governor's letter, which is essentially a formal request for approval of the Class 6 primacy program. This letter will also affirm that the state is both willing and able to carry out the program as required. When folks look at our application that's out there, this is currently a placeholder. We will get the final governor's letter at the end of our second hearing in April. Next is the Attorney General's statement. And again, this is very similar. It will be a placeholder until after the second hearing, but will be part of the final application that we submit. Essentially, the Attorney General's statement certifies that Colorado state statutes, regulations, and judicial decisions provide adequate authority for administering the program. The memorandum of agreement between the state and the EPA outlines the provisions and arrangements regarding the administration, implementation, and enforcement of Colorado's Class 6 program. This agreement will be a key document in the process and may be something stakeholders want to review as well. The version of the agreement we are submitting with our application should be viewed as a draft, as ECMC will continue to negotiate this with EPA before it's finalized. Then we have the applicable state statutes and regulations. This will include copies of all relevant state statutes and regulations, including the crosswalk, as I mentioned earlier, which compares state regulations with federal requirements. This is a robust compilation and is not for light reading. It's currently sitting at about 500 pages, so apologize for that, but it encompasses everything for our program. And finally, for compliance with public participation, we are beginning to satisfy that requirement today by issuing a public notice, providing at least a 30-day public comment period, and scheduling a final public hearing on the matter. These steps ensure transparency and provide opportunities for stakeholders to be involved in the process. The draft application will be available for public review and comment beginning tomorrow, which I mentioned earlier, starts the required 30-day public participation process. Comments can be submitted either through the docket via the portal or by signing up for public comments using the link in the news and notices section. And as I mentioned, the system will be open starting tomorrow through March 21st. To enable the public to weigh in, we will post the application and a link to provide comments on the ECMC website. And for those looking to access the draft application, again, it can be found in the shared public Google Drive, or directly on our homepage. We will also send an email with the pertinent information to people who have expressed interest in Class 6, and we will publish public notices in a couple newspapers to ensure we have coverage throughout the entire state. And finally, we've added an additional document. We've prepared an executive summary of our application, which essentially provides an overview of the application's key points. These are both available in English and Spanish, and we will post those along with the rest of the material. So we encourage members of the public to submit comments on the state's primacy application. I would like to clarify that the only comments we can take action on are comments on the primacy application itself. We do not have the ability as part of this process to revisit the 1400 series Class 6 rules or the state and federal requirements. After the public comment period, staff will compile and review all comments, engage with stakeholders for further discussion where appropriate, and incorporate feedback into the application as needed. And we will also hold a follow-up hearing on the final primacy application on April 2nd. And afterwards, our goal is to submit the application as quickly as possible to EPA. So wrapping it all up, today marks an important step in the state's effort to secure primacy over Class 6 UIC wells. We appreciate everyone's engagement throughout this process and encourage you to take time to review the draft application and provide comments during this period. We look forward to continuing to work with our stakeholders as we move through this process. I will also say we are on the process of setting up a specific Class 6 email address, and that should be active in the next couple of days. So please don't hesitate to reach out with any questions or if further clarification is needed. Thank you for your time and participation today, and that concludes my presentation. And now I'd like to hand it over to AG Mercer-Gelman for a couple comments. Thanks.
Thank you, Mr. Seeley, and good morning to the commissioners. For the record, I'm AG Lauren Mercer-Gelman and have been working closely with staff on all of the Class 6 efforts. I'm coming to you because one of the reasons we are here today is because staff has a request of the commission. So as Mark mentioned at the beginning of the presentation, by Colorado statute, before ECMC can seek primacy from EPA, the commission has to make a determination that ECMC has the necessary resources to administer the program outlined in the primacy application while ensuring safe and effective regulation of carbon storage. And although the commission has indicated its support for the Class 6 program through the Class 6 rulemaking and a number of other efforts, in order to ensure compliance with statute, we are asking the commission to make a formal determination to that effect. So if it's the commission's pleasure, you could make a motion here today to take up this finding with a plan to hold a vote at a subsequent hearing on whether ECMC has the necessary resources to safely and effectively administer the Class 6 program outlined in staff's primacy application. With that, we could ensure that the matter is properly docketed and noticed for the subsequent hearing. So that's all I had to add, and I believe at this time we are eager to answer any questions that the commission might have.
Great. No, thank you both for the presentation. Happy to talk about the motion in a bit. Let's have Q&A first. One quick question for either yourself, Ms. Mercer-Gelman, or Mr. Seeley. The public comment section, where people have this 30-day time frame to put in written public comment, that's going to be a little different than what's maybe some of our stakeholders have dealt with or thought about when we're doing rulemakings, where we have a rule, like right now we've got a primacy application, it's published as public comment. In other instances in which we have a rule, we put a draft out and then we seek party status from stakeholders, and then we have this formal proceeding and people get time to advocate and lawyers are involved. That's not what we're doing with this primacy application. I just want to make sure that I'm correct on that front and that our stakeholders understand that it really is a 30-day window for written public comment.
That's correct, Mr. Chair. It's really more similar to the typical public comment opportunities we provide at a weekly commission hearing. It's not a formal process. folks can go through a portal on the website or through e-filing once there's a docket set up, but the website portal is probably the easiest, and just provide their comments about the primacy application. I think it's worth reiterating what Mr. Seeley said before, that, now is not, we don't have the ability to go back and revisit the rules or any of the sort of prior determinations that have been made related to Class 6. It's really looking for comments on the application that we're submitting to EPA. And we're looking forward to getting those either in writing, or there will be an opportunity to sign up for oral public comment at the subsequent hearing that we have on this.
Great. Thanks for that clarification. The second follow-up question for either yourself or Mr. Seeley. What can you inform the commission and thus our stakeholders about any dialogue or discussion that's been had between ECMC staff and the EPA? I mean, are we just going at this cold, or has there been opportunities to have discussion about how to craft the application so that it potentially is going to be successful?
Yes, Mr. Chair, thank you for that question. Much like when we were going through the rulemaking last year, we continue to have a consistent engagement with EPA that has continued through the end of the year and the beginning of this year. We meet with them on a weekly basis to talk about the application and questions as we go through. So this has been very much a parallel effort with the region as we progress it forward.
And if I could add just one thing to that, is that the conversation won't stop once we submit our application. We're prepared for a very iterative process with EPA where they review our materials, and if they see any issues or questions, they reach out. We can make changes upon request. So it's not sort of that the primacy package is locked in stone and that we get a thumbs up or thumbs down. It's going to be collaborative with EPA to get it over the finish line. And one item to particularly highlight is the memorandum of agreement with EPA. What we are submitting is our draft of, our first shot at it. It hasn't been negotiated with EPA yet, so folks should review it in that light, knowing that it's not finalized. They very well might ask us to make some revisions to that. It will be an ongoing fluid process with lots of engagement with EPA.
In that memorandum of agreement, that's kind of the working paper on how EPA and ECMC will work together, or is that what that is?
Exactly.
Okay, great. Well, thanks for taking my questions. Do other commissioners have questions? All right, well, seeing no further questions, I just want to commend staff. It appears you pulled together a strong primacy application that is representative of the great work we've been doing in Colorado to become a leader in regulating Class 6 carbon storage wells. Again, it looks like there's been extensive work to get to this point, including securing authority and funding from the legislature, ensuring that our staff has the necessary expertise and resources to succeed, conducting numerous studies on how to best regulate this emerging technology, conducting a successful Class 6 rulemaking that we just recently undertook, and now putting together this package for EPA. Based on all of that, I, as one commissioner, feel confident that Colorado has the necessary resources to administer the Class 6 program in a safe and effective manner. With that said, I'll move pursuant to Rule 503A that at the Commission's hearing on April 2nd, this Commission formally take up the question and make a determination on whether the ECMC has the necessary resources to administer the Class 6 program in a safe and effective manner. So that is a motion. Do we have a second?
Second.
A motion and a second. Is there further discussion on the motion? Commissioner Messner?
Thanks. I don't have a problem with the motion. I'm trying to understand why we're doing this motion to then have a second formal motion at a further hearing. I guess I just don't understand that procedurally.
Good question. AG Mercer? Bellman?
Thank you, Commissioner Messner. Our thinking was just to be thorough and making sure that it was properly noticed. I don't think the agenda for today reflected that there would be a formal decision made by the Commission. So that was why I suggested having it taken up at a subsequent hearing.
So this motion is really just a direction to put this on, to create a public hearing.
Correct.
Okay.
Commissioner Ackerman?
Thank you. I appreciate that explanation. And while I know we have hired individuals specifically with this expertise, and while I've had a chance to interact with them and we have great expertise on staff with regard to carbon capture, will there be more information presented in a formal manner at that hearing with regard to the resources that we have with staff, Ms. Mercer-Gelman? Or is that something that if we had questions, we should look into individually between now and then?
Mr. Seeley?
Thank you, Commissioner Ackerman. As part of our primacy application, we outline the structure and the organization and the folks that are going to be responsible for administering the program. So we can definitely bring that forward in the subsequent hearing and present that as part of the record.
Thank you, Mr. Seeley. My recommendation would be to follow the requirement, and I suspect you're already down this road, but to follow the requirements of EPA and what those requirements are, and specifically how we meet those at the staff level.
So we'll look forward, I appreciate that, Commissioner Ackerman. So we'll look forward to a short presentation that sort of bolsters the concept that the ECMC has the necessary resources to administer the Class 6 program in a safe and effective manner. Is that fair?
Sounds great.
Further questions? Further discussion on the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries. Great. We'll look forward to seeing you on April 2nd. Hearings Manager Thomas, if you can make sure this gets agendized appropriately for that meeting, and we'll look forward to a short presentation from staff highlighting the points as raised by Commissioner Ackerman concerning the bolstering the fact that there are the necessary resources to administer the Class 6 program in a safe and effective manner. All right, that takes care of that agenda item. The other next item is docket 231-200-372. That is the Secret Stash OGDP by GMT Exploration Company. Let's take 10 minutes. Let's get, we've got some public comment that will go first. Let's go ahead and get the first 3 or 4 folks lined up and then get Attorney Jamie Jost and her clients ready to go as well. And then we'll swear in witnesses and proceed from there. It's 9:28. We'll return at 9:38. All right, welcome back, folks. We'll take up docket 231200372. This is an oil and gas development plan. It's a continued docket. The applicant is GMT Exploration Company, and the name of the docket is the Secret Stash OGDP. Ms. Jost, I see you present. We'll get to you just in a bit. We're going to take public comment first, and then we'll get to you and swearing in of your witnesses, and then hear your case in chief after that. Is that appropriate? Okay. All right. We have a few folks that have signed up for public comment. I would note that normally when it's a continued matter, we don't do additional public comment, but I don't think we were clear in this instance. And so we're going to go ahead and take up public comment. Each person will receive 3 minutes. We've got a timer on the screen. We'll start with Jason Ephraim.
Thank you, Commissioners. My name is Jason Ephraim, and I live at 6946 South Titus Street in the South Shore neighborhood. I wanted to thank you for the opportunity to comment on this application. As I stated in my previous comment, the first review of this, that this location should require electrification. It falls under the Lowry Ranch cap, and it should follow the same rules as other sites in that area for the same reasons that they were enacted for the cap itself. Consistent standards are important for both public health and environmental responsibility. Secondly, I'd like to say that this site is now within, I believe, half a mile of the newly platted Trails at Overland Ranch. That's in section 34 on the GIS. And there's already an initial phase of 400 homes planned with an expansion of approximately 1,000. And both the county and the ECMC need to consider these future homes and potential schools, public parks, daycares, don't know yet. When reviewing this application, as there will be residents within a dangerous proximity to this well. Health and safety really just shouldn't have to be in a foot race against operators to see who gets the finish line first, who gets a home or who gets a well approved or in the ground. And most importantly, and this kind of relates to this procedure and process and not being clear, but in my understanding, I'm not sure if this hearing can actually proceed because according to Rule 306, Section D, Paragraph 1, public comment can only start after the director approves of Form 2C and posts all required materials, including the full application and supporting material on the website. And I didn't really realize this until I started looking last night to prepare my comment, but the Form 2B under the pending oil and gas location assessments on the portal, which is normally the place where it's indicated that a 2B would exist, director recommendation, 2C status of the well. The only thing that I could find a 2B was evidence of the operator having done an improvement project with no evidence of an actual 2B form completed or otherwise. Similarly, I couldn't find the director's recommendation inside the documents folder that's indicated that are related to this secret stash application. So basically my belief, because there have other people that have joined since this comment process was kicked off again. I'm not exactly sure on the rules and clear, but my assertion or that commission should take a look at that. And if the public comment period was either compliantly started or if at some point that was taken down and it was basically invalidated at that point, and if a new comment period should be started up as well as a new hearing, just based off of people that be commenting and reviewing these materials, not having complete access to everything that it seems to me that the rules layout should be available. So that's it. I wanted to thank you again for taking the time and appreciate your attention in this matter.
Thank you for the public comment this morning. We'll now hear from Marcia Goldsmith-Kamen.
I am Marcia Goldsmith-Kamen, and I'm asking you to continue the stay or deny this application because cumulative impact analysis is incomplete. The commissioners previously clarified that all 20 wells in the OGDP need to be modeled based on most likely development scenario, not worst case or best case. Where is the use of the most likely scenario defined in your state regulations? This is not a common practice in industry. For example, process safety management and environmental consequence analysis require consideration of worst case scenarios because it allows for the identification of the most severe potential consequences of a hazardous process, enabling companies to take proactive measures to prevent such incidents, even if they're considered highly unlikely, by designing systems with adequate safeguards and mitigation strategies to minimize damage in case of a catastrophic event. In the case of assessing community exposure to airborne emissions, the most protective and supportable airborne criteria must be used. This is particularly true for assessment of cumulative impacts and calculating hazard indices, especially for carcinogens like benzene and ethylbenzene. There's no supporting information in this document indicating how GMT determined most likely development scenarios. By modeling and planning for worst case scenario, it helps the community to understand how we will be protected in the event of severe potential consequences. Simply saying there'll be minimal odor impacts, quoting the same tired and disproven 2017 report, and concluding that based on these reports and finding it's not anticipated that the proposed operation will present any potential acute or chronic, short or long-term incremental impacts to public health. That's not enough. The community deserves assessed data for individual chemicals and for cumulative exposures. The study that was referenced, Assessment of Potential Public Health Effects, 2017 McMullen, is weak on supportable data, and the accuracy of distance-based exposure assessments is questionable. Specifically, the assessment did not adequately address potential long-term health effects from chronic exposure. Critical reviews of this study generally acknowledge the study found low levels of air pollutants near oil and gas operations, indicating a low risk of immediate health effects, but highlights concern regarding potential limitations in data collection, exposure assessment, and need for further research on long-term impacts. We continue to ask for unbiased, third-party scientific research to be completed prior to ruling on this application. Thank you for allowing us this time.
Thank you, Ms. Kamen. We'll now hear from Randy Woolard.
Good morning, Commissioners. My name's Randy Willard. I live at 5206 South Haleyville Way in Aurora. I appreciate the time to comment today. I'm going to follow on with Marcia's comment, which highlights our toxic and remediation experts' take on the revised GMT application. Based on the levels of emissions expected to be released during the implementation of the production phase of this proposed project, the contribution to past, present, and reasonably foreseeable projects represents a minor cumulative increase to emissions in the air within the project area. Simply saying that there will be minimal odor impacts or emission impacts, quoting the same tired and disproven report that Marcia has mentioned repeatedly, and concluding that based on these reports and findings, it's not anticipated that the proposed operations will present any potential acute or chronic short or long-term incremental impacts to public health is not enough. The community deserves to know the assessed emissions per volume or in parts per billion compared to acceptable criteria. They need reassessed data for the individual chemicals and for cumulative exposures. Per my previous comments on Dr. Mullen's report, a similar issue with dust hazards from use of sand as a propellant in their statement that 0 pounds of silica dust are anticipated to migrate off the secret stash pad during completion operations. This is an assumption, not a provable fact. Has GMT performed analysis of the sand they propose to use? Do they have a supplier statement stating 0% silica? Have they mentioned during actual use of sand? If so, what are the results? Crystalline silica is prevalent in sand and is a confirmed human carcinogen. People need data. They continue to mention and use 9 parts per billion as the acceptable level of airborne benzene. The Agency for Toxic Substances and Disease Registry has established several limits for exposure to benzene, including acute duration of 9 parts per billion, intermediate duration and inhalation of 6 parts per billion, chronic duration inhalation at 3, and chronic duration via oral at 0.0005 milligrams per kilogram per day. 6 parts per billion would be the appropriate criteria to use on the numerous studies I reviewed in the hazards of benzene. At the end of the day, this simple redo is another attempt by GMT to slide things through that simply don't jive with reality. Thank you for your time today.
Thank you, Mr. Willard. We'll now hear from Mark Goldsmith-Cammon.
Good morning. I am Mark Goldsmith-Cammon, 27235 East Lakeview Place in South Shore, Aurora. And I pick up a little bit on Jason's comment, because in their application, GMT stated that the nearest RBU is approximately 3,138 feet away from the well pad. What they didn't say is that the well pad is only about 1/2 mile from the large planned residential development, the trails at Overland Ranch, which was originally called the Butterfield Trails, in neighboring sections 34. It's also just over 1 mile from Blackstone, an existing large and densely populated residential area, including schools and other businesses. These are areas that are already suffering from various environmental issues. Note that Secret Stash is located within the boundaries of Crestone's Lowry Ranch Cap. This is an area that the ECMC has previously determined must have full electrification for all phases of oil and gas development, and the Secret Stash well pad must be subject to those same requirements. Secret Stash plans do not currently have commitments to meet requirements for full electrification, and don't even have full commitments to use Tier 4 engines for either site development or the truck fleet that would be making tens of thousands of trips to and from the well pad. The ECMC must make full electrification of all phases of development a requirement for Secret Stash to protect the health, safety, and welfare of the public as well as the environment of this region. In addition, GMT should be required to build pipelines for the transport of all fresh water and produced water, as well as the transport of produced oil and gas. This will serve to minimize the number of truck trips and potential accidents and spills, thereby protecting the nearby residential neighborhoods as well as the environment. This application is deficient in many other areas, including the total lack of consideration of the cumulative impacts when combined with the large number of other wells in the area of the Lowry Ranch Cap, for example, the Civitas Crestone wells, which are like over 160 wells. The ECMC should once again reject this application and send it back to GMT to be properly completed before any further serious consideration is warranted. Thank you for the opportunity to speak today.
Thank you for the testimony. We now will hear from Ann Hussein.
Good morning, Commissioners. My name is Ann Hussein, and I'm a resident of Southeast Aurora. I'm speaking of air quality. In the first hearing, it was stated that Secret Stash is in a great location to protect public health and safety. No homes without 3,000 feet, not densely populated. Well, there is a densely populated neighborhood barely a mile from Secret Stash, a neighborhood which will have another well pad and 20 more wells 3,000 feet from their homes. I have never met a resident who lives within a mile of a large 20-well fracking pad tell me they feel safe. The only people who feel good about this setback are the regulatory bodies and the operators. This is still Southeast Arapahoe County, still in a non-attainment zone. We consistently have a high percentage of days with high winds, and air has no boundaries. The overall air quality of our county will seriously suffer. We are located in the Front Range and have many poor quality ozone days. I'm looking at the new truck traffic chart presented by GMT. Secret Stash well pad is an example of allowing the operator to go backwards in best management practices, allowing two occupations where the drilling and fracking and rig has to be hauled back another time via semi-truck traffic. No pipeline for oil and gas allowing semi-trips, no pipeline for toxic wastewater. And the third-party trucking company with 3,500 semi-trips with Tier 3 diesel engines transporting this across our roads. How many miles will all of these 3,516 semi-truck trips travel to the pad, leaving the pad, going how many miles to their final destination? During completions, there will be 1,764 semi-truck trips in 37 days. That's a hell of a lot of diesel truck emissions on a daily basis. It says GMT will monitor air quality actions on action days for ozone, and that they'll do these measures when feasible. Minimize traffic, reduce truck traffic and miles, delay refueling, suspend fossil fuel powered equipment, postpone construction, postpone well maintenance, postpone or reduce operations with high potential for emissions. Where will these actions be documented, and who will verify that GMT has done all of the high action, all of these restrictions on these high action days? If nobody if there's no documentation and there's no oversight on this, then this further deteriorates our air quality. CDH Consultants, it is led by a team of former industry professionals, and they compose the air quality mitigation plan. And I quote, "They know how to thread the needle of compliance management." That's from their website. The fact that operators are still using CTEH consultants to provide research and data showing no public harm will occur during oil and gas projects is a slap in the face to all of us. Accepting this data is showing us that the bottom line is more important than the public's health. We must use non-industry third-party consultants for non-biased emission data. Will the state take away control of research from the industry and hire independent consultants to provide this data? Thank you.
Thank you very much. We'll now hear from Michael Rose. Mr. Rose, I see you're with us. Do you want to unmute? All right, we'll keep working on Mr. Rose.
Here I go. Here I am.
Oh.
You hear me now?
Yeah, I can hear you now. Go ahead.
Okay, sorry about that. I'm Michael Rose. I live at 426 South Washington Street in Denver. However, I am a user of the Aurora Reservoir, and I'm very concerned about the air pollution, as I have respiratory issues, and a number of my friends also do as well. I have a master's degree in counseling, as well as a master's degree in community health which is a public-oriented curriculum with coursework in epidemiology. I have over 30 years of clinical experience as a counselor in community mental health and criminal justice systems. Public comment and discussion about the adverse impacts of unconventional oil and gas development, otherwise known as hydraulic fracturing, often focus on physical health. It is important to also note that a growing body of research evidence points to unconventional oil and gas development impact on mental health. For example, a study published in September 2024 in the American Journal of Public Health looked at mental health survey data for 5,725 people, including residents across 37 states and Canadian provinces who were planning to get pregnant. They found that people who lived roughly 6 miles from active oil and gas development were more likely to report moderate to severe depression than people living 12 to 31 miles away, and that high levels of active oil and gas activity were linked to higher reported levels of depression. They also found that the closer people live to oil and gas operations, the higher the intensity of their stress levels. As well noted before, there is also a fair amount of information about the impacts of fracking in public health. There are more than 100 studies showing public health harms that now linked with drilling, fracking, and associated infrastructure are well established. They include cancers, asthma, respiratory diseases, skin rashes, heart problems, and mental health problems. Multiple corroborating studies of pregnant women residing near fracking operations across the nation show impairments to infant health, including birth defects, preterm birth, and low birth weight. Emerging evidence shows harm to maternal health, including elevated risk for eclampsia during pregnancy and shortened lifespans among older residents living in proximity to oil and gas wells. There's also a concern I have about the lack of transparency or disinformation about harmful fracking incidents. With this application, we noticed that there are a number of chemicals that were not disclosed or not reportable, and this is especially concerning, even though they're considered.
Mr. Rose, we can no longer hear you.
1% is to allay fears about. Okay.
If you could wrap up, you're out of time, but would like to get you to wrap up, please.
Okay. Anyway, we're concerned about the impacts of these chemicals on the health of prospective residents who would live near the secret stash site. Thank you.
Thank you very much. We'll now hear from Sally Ingen.
Sorry, yep, I'm here.
Yep, we can hear you.
All right, great. So, good morning, commissioners. First, I'd like to share that while we appreciate the opportunity to speak about the cap, I feel there should have been an earlier notice of this hearing. That would have given us more time to look over the information. The first I saw of this hearing was on Saturday, February 15th. Monday was then a holiday, and that really only gave me one day to look into the new proposed plan. Since GMT has a full-time crew of paid attorneys with weeks to put their best foot forward, it would only be fair to give the citizens much more time. Most of us had to take time off work to even to be on this call. In your statement that we should not be able to talk on continuations earlier in this meeting, I feel we should have that right to be able to speak on that, as I'm sure the applicant has changed their information on their application, and it could very well affect us. So on page 4 of the GMT PowerPoint to the ECMC, GMT states, and I quote, GMT expressed efforts and desires to implement infrastructure as development progresses, including electrification of the site and oil pipeline infrastructure. Efforts and desires, I know what efforts and desires look like to me. I'll make an effort to buy a lottery ticket today because I desire to win the lottery. That's just the wrong thing to say. That statement sounds like they will be electrified as soon as they are ready. GMT wants to start soon. Has electrical been brought to the site? I don't think so. EMC ruled that electrification is mandatory throughout the entire fracking process, not simply as the fracking company finds it is convenient to incorporate electrification as the job goes along. This goes completely against the rules we all worked on so hard. I'm surprised they would even say that we'll make an effort, that they could try, that they desire to, but won't promise to use electrification as work goes on. You must put a stay on this project until GMT can incorporate electrification before they start, which means they're going to have to bring electricity from Xcel or Core Energy or however they're going to do that. If they break this rule, what will stop them from disregarding all the other rules? Will the ECMC visit the site and stop all the work? Being that this is the first pad to be built in the CAP, the ECMC must set an example that the rules are followed as directed, not express their efforts and desires. GMT must not be allowed to start before electrification is brought in. There's a little problem. Kelly Hansen or John Hansen, who's to speak last. I don't see them on the list, but his wife, Kelly, John is sick, but his wife, Kelly, is here, so she could give her statement. She's right here. Can she come on next?
Next is Amanda Stevenson.
Okay,
And then we'll hear
then
from-
after Amanda, can she come on?
Yeah, then we'll hear from Ms. Hanson.
Great. All right, thank you.
Go ahead.
Good to go?
Yes, you're good to go.
Okay. Good morning, ECMC commissioners. I want to talk to you today about the risk of fires and Aurora's inability to stop fires near a fracking facility. There are 6 major concerns we have. The first, the fluids used in fracking are highly flammable. The high potential for leaking release of these fluids. Static electricity, sparks from machinery, and even cigarette lighters or cigarettes can ignite leaked flammable gases. Lightning. Blowouts can cause large-scale fires. Chemical reactions between chemicals used in fracking have been known to create flammable substances. Speaking to like the Marshall Fire, which I know has nothing to do with fracking, but is a demonstration of the devastation a fire can do without the use of chemicals. Over 1,000 homes and businesses burned and countless more lives devastated from this tragedy. These fires were fueled by high winds and drought with a slight spark. Those conditions not only remain, but continue to get worse with climate. And out here, it is obviously going to continue to happen. There is not an emergency plan set in place for how the fire departments will respond to such an event at fracking locations, which shows lack of planning and naivety. As far as we know, when a fire is reported, the call goes first to Bennett Watkins. If they need help, they call Rattlesnake Fire Department, who will only respond to Bennett Watkins when they call for help. It takes Bennett 20 minutes to get the sunlight long. It will take them longer to get to Secret Stash, if they know where the access roads are. The worst thing is neither of these departments have a 24-hour hazmat crews. This is dangerous to our firefighters who protect us day in and day out. Aurora does, but they do need to be called in by Bennett, who has access to the situation first. In addition, the CI plan states that there are no water bodies in areas proposed for disturbance. They omit the fact that there is still a potential to impact water bodies due to the primary issue with flash floods in dry drainage areas along Colorado's Front Range. Recent wildfires have left large burn scars, causing soil to become highly water repellent, leading to rapid runoff and severe flash flooding, even with a moderate rainfall, particularly in areas with previously dry drainage channels. Essentially, the burned ground can't absorb water effectively, causing it to flow quickly across the landscape. It's another potential risk. I implore the ECMC to put a stay on this application until surrounding municipalities are able to build appropriate fire stations and hazmat crews that are adequately staffed to fight a fire with a good plan. I do not feel pity for GMT. There are millions of other acres that are not close to people's homes that they could have chosen to frack, and those acreages are still available, yet they choose to try to disturb the people who live around them. Thank you for your time.
Thank you very much, Ms. Stevenson, for being with us this morning. The last public commenter was John Hanson. I understand that either Mr. Hanson or Ms. Hanson is available via phone. Mr. Thomas, can you, let's see, where are they?
Sorry, this is Kelly.
Okay, go ahead.
Good morning, Commissioners. I would like to talk about the how to minimize public health risks. I would like to start off by reminding the ECMC that Colorado Constitution states, quote, "State and local governments and their agencies shall assign the highest priority to the protection of a healthy environment." Healthy environment, as defined by the state, means safe and sustainable conditions for human life, including healthy air, water, land, ecological systems. I want to talk to you about GMT's promise to, and I quote, "protect and minimize adverse impacts to the public health, safety, and welfare." Is GMT able to quantify that? Does that mean we can have 25 cases of childhood leukemia, 150 visits to the emergency room for children under 12 with bloody noses, and 200 cases of cancer? Or is it a percentage, say 5% of people with, quote, "adverse effects," and then we will have reached the number of deaths and illnesses? How will GMT react? When GMT states they will minimize adverse effects, that means that we will know there will be adverse impacts. This directly is in conflict with our state constitution. My guess is their high-paid legal team will dispute the illnesses and drag cases out of court so long that ordinary people will not be able to afford to keep fighting. That is, if GMT does not hand down ownership to LLC after one and nowhere to be found when we have to bury our children. GMT will argue their site is more than required distances to schools and homes. GMT plans to be at the site for 20 years. Butterfield Trails, aka Trails at Overland Park, is planned subdivision that, according to maps, butts right up to Secret Stash. What happens when houses are built within 3,000 feet of the pad? Who wins? I want to know the answer to these questions. It is documented facts that people are left hanging by large corporations who continue not to be held accountable for their actions. Let's take an opportunity here to protect Colorado citizens. This is the ECMC's duty to fulfill. Remember what I read earlier about the Colorado Constitution. Are you sworn to do and put a cap on GMT until more people can be clear how they intend to respond to the allegations that the wells are making people sick? Thank you for your time.
All right, thank you very much. Mr. Thomas, can you confirm that takes care of the folks that signed up for public comment?
Yes, that is correct. We've gone
Okay.
through everybody that signed up.
Okay, two comments from me as chair to the comments we just received. One, there were several statements from individuals that the secret stash is part of the Lowry cap. It is not. And the commission made a finding to that extent at the last hearing. So just want to make sure that people understand that this is not part of the Lowry cap. It is a distinct and OGDP. The second issue, and this is a question for staff. I take public comment seriously. There were some concerns raised by Mr. Ephraim and a little bit by Mr. Goldsmith Cameron concerning an inability to access the Form 2B. That could be, and I want to make sure that we understand and at that point. And I guess what I'd like to do is maybe call for a short break to let staff look into that to confirm or not the efficacy of that statement. So it's 10:10. Let's return at 10:25. And that'll give staff a little bit of a time to look into that and report back before we move forward on the merits. So back in a bit. We're back on the docket. I don't have the docket number in front of me right now, but it's the secret stash OGDP. I believe that our staff was instructed by me to look into this Form 2B issue. We're in kind of uncharted waters here, folks. My understanding is that the public comment period was like a year or so ago, and that there was a 2B that was available at that time. We took this matter up on January 8th, I think, and at that hearing, we provided information to the applicant that we wanted the 2B to assess the full 20 wells and not some subset of wells. And so a new Form 2B was filed I understand it was available. I also understand that perhaps it was not available. And so now that's the extent of my knowledge here. I would note that technically public comment wasn't supposed to reopen with the filing of the new Form 2B, but I also want to make sure that, the public has an ability to weigh in on the relevant matters here. Ms. Mercer-Gelman, can you clarify and also provide some direction to us?
Thank you, Mr. Chair. Your summary was accurate. Just to provide a little more detail. So as the public commenter here today pointed out, Rule 303D1 requires, and I'm reading from the rule, when the director makes a completeness determination by approving a Form 2C, the oil and gas development plan application components, exemptions granted pursuant to Rule 304D, and supporting materials will be posted to the Commission's website. So in other words, our rule requires that after an application passes completeness, all of the application components are required to be publicly available so that the public can access them during the comment period. Staff looked into this over the break and was able to determine that the original Form 2B was available during the rule-based public comment period. As you articulate, so we're in compliance with the rules there. As you articulated, the unique situation here is that after the January 8th hearing, the Commission directed GMT to revise and submit a new Form 2B. GMT submitted this via the e-filing system on February 12th, so 1 week ago, and it was intended to be uploaded to the ECMC website, but essentially glitched in the upload. Staff looked into this and just moments ago was able to get it up on the website, but it was not there until now. So that's sort of the background situation. My advice is that, the rules don't directly contemplate this situation. There is no requirement that the public comment period be reopened when a matter is continued. But the Commission, I think, has at least a couple options as I see it here. You could move forward, acknowledging that 303D1 was complied with in the original public comment period, or you could reopen public comment. That's something the Commission always has discretion to do, to allow the public to react to this new Form 2B. The public comment period for this application was 30 days, so that would probably be the appropriate amount of time if the Commission wishes to go that route. I would point out also that I view this strictly as a public comment issue. There are separate rules governing the petition period, and no petitions were filed on this application, and I wouldn't view reopening public comment as having any implication that we would be reopening the petition period. So that's my take. I'm happy to answer any questions commissioners may have.
We'll do two things next. Any questions to AG Mercer-Gelman from commissioners, and then I'm going to allow the applicant's attorney to speak to the issue. Commissioner Messmer?
So AG Mercer-Gelman, just a question about the public's access to the portfolio, understanding that the Form 2B was available in the portfolio for some amount of time, because I've been looking at it as I've reviewed this application. So does the public have access to that? Are they able to view that 2B as part of the other application submittals that were part of the portfolio, either through e-forms or the e-filing system or through the Google Drive?
Thank you for that question, Commissioner Messner. That's a great point. Yes, the public has access to the Commission portfolios. They're linked from the hearings page on the ECMC website and all publicly available. And so the public could have viewed the Form 2B in the portfolio, and it was uploaded, it appears, on February 13th. So it's been publicly available there. Also, the e-filing system is publicly available, so folks, if they knew how to get into the e-filing system, they could have seen it when it was filed on the 12th. So it has been available in both of those places for about a week.
Okay, thank you.
Any other questions for AG Mercer-Gelman? All right, Ms. Jost.
Wonderful. Good morning, commissioners. Thank you, Chair, for the opportunity to comment on this. We just, from GMT's perspective, GMT's been working very hard from the January 8th, 2025 hearing and had worked with staff as well as had some conversations with CDPHE about the Form 2B. I just want to reiterate that the Form 2B was uploaded via web forms on the 12th. It was also uploaded via the e-filings hearing system on the 12th. It's been in the hearing portfolio, as Ms. Mercer-Gelman stated, from the 13th. It was also, again, from our standpoint, included in the hearing presentation because we did want to ensure that anyone who was reviewing the hearing presentation, including the public, had full access to the Form 2B as well as the CI plan and the DUS plan. So all of those have been publicly available in various spots on the ECMC's website since last Wednesday. So we would request that the hearing progress today. I'd also like to mention there are no formal petitions to this application. This would be a public comment concern only and not petition. So Ms. Mercer-Gelman, I appreciate the clarification on that as well. But we would request that the hearing progress today. Thank you.
Thank you, Ms. Jost. Questions for Ms. Jost? All right, seeing no questions, commissioners, we have the decision before us today, which is whether to continue with the hearing today or whether to delay the hearing for another period of time to enable additional public comment. Does anybody have thoughts they would like to share on that issue? Commissioner Cross?
Thank you, Chair Robbins. I, for one, am happy to move forward with looking at the application, the updated information that we plan on seeing here. As has been discussed, I don't think that, I appreciate that we took the additional time for additional public comment, but I don't think we need to open it up for new public comment or anything else. As I don't think that was necessary at the time. There have been numerous opportunities for public comment on this already. And we're looking at updated information that we as a commission requested from the applicant before. So I'm ready to move forward.
Yeah, I think I'm in agreement with you, Commissioner Cross. What do the other two commissioners think? Commissioner Ackerman?
I don't think I have an objection to that either, although I will note it as disappointing that we did have that glitch. We're not perfect, and I get that. I think we are in compliance here, and I am sensitive to public comment. Certainly, we've listened to much public comment on this specific OGDP and surrounding areas, and the public comment that we heard today was significantly duplicative of public comment that we've heard in the past on this. I think it's I think we do get the gist of the public feeling on this application enough to move forward.
Appreciate those comments, and I agree with the comments as well. Commissioner Messner?
Thanks. I do think that the rules do have been met in this particular situation. I think that while we don't have clarity around public comment associated with continuances as part of our rules, I've certainly been on commissions that do it both ways. So allow for public comments if a application has been significantly modified, and then also been on ones that do not allow public comment as part of a continuance. I think it would probably benefit us to create some clarity on that as far as how we're going to deal with continuances and public comment associated with that, and then any kind of timelines associated with that necessary public comment and review. But I think the rules as written right now don't contemplate public comment as part of a continuance. I do think the public had access to the hearing presentation and the Form 2Bs at the same time that I had access to the hearing applications and the Form 2Bs. And I think we did allow public comment, and that was good public comment that we heard today. There was good points that were made, but I'm comfortable moving forward with the hearing as the information I do think was provided publicly and meets our rules. So.
Very good. We've heard from all four commissioners. We will do two things. One, we'll instruct AG Mercer Gelman to work with staff, perhaps in your new capacity, to create a appropriate protocol when we're asking for a continuance, and maybe it's a substance of changes, et cetera. I don't believe there's a need to change rules, but if we could get some guidance around that, that would be great. And then Ms. Jost, with that, we will hear your presentation of the supplemental case in chief. We would first ask you to visualize your witnesses so that we can get them sworn in.
Wonderful. Thank you, Chair. Ms. Gross, Mr. Schuster, Ms. Hagar, Mr. Jones, and then Mr. Blair. Can you please come on screen? Wonderful. Ms. Mercer-Gelman, we've got everyone.
Thank you very much, and good morning to the panelists. I will go one at a time and ask that you each raise your right hand, state your name, and that you swear to tell the truth. Let's begin with Ms. Gross.
My name is Andrea Gross, and I swear to tell the truth.
Thank you. Mr. Schuster?
My name is Hans Schuster, and I swear to tell the truth.
Thank you. Mr. Blair?
My name is Max Blair, and I swear to tell the truth.
Thank you. Ms. Hager?
My name is Sarah Hager, and I swear to tell the truth.
Thank you. And finally, Mr. Jones.
Alex Jones, and I swear to tell the truth.
Thank you very much.
Wonderful. Thank you.
Ms. Jones, the panel is yours.
Wonderful. Thank you, Chair. Ms. Gross, would you go ahead and share our PowerPoint? Chair, just give us just a minute and we'll get that up. Andrea, we're not seeing anything yet.
Sorry, just.
That's okay. No worries.
Went away. So. There it is. Okay.
Okay, and can you take it back to slide 1 and then put it in the slide? There you go, slideshow mode. Excellent. Thank you so much, Chair. I'm good to go if you are.
You are good to go.
Wonderful. Thank you so much. Well, good morning, commissioners. My name is Jamie Jost of Jost Energy Law, and along with my partner, Kelsey Wieselinki, we represent GMT Exploration in the Secret Stash 56535 OGDP before you in docket number 2312-00372. Thank you for having GMT back today to present additional Form 2B and emissions information on the Secret Stash OGDP to this commission. Before we get going, we would really like to thank you for the guidance provided at the January 8th, 2025 hearing as it relates to this commission's expectations on Form 2B information submissions, the time periods or phases of operations to be reviewed as part of the Form 2B data inclusion, and the air emissions information tied to traffic and trucking. Our January hearing was the first time this commission had so clearly stated its expectations on these items, which was extremely helpful for GMT. We also want to thank the ECMC staff for their discussions with GMT after the January 8th, 2025 hearing, and for taking the commissioner's guidance and preparing a Form 2B Air Resources and Public Health Resources sections of the Form 2B guidance, which was provided to GMT on January 23rd, 2025. This January 23rd, 2025 guidance is the first guidance on the Air Resources and Public Health Resources sections of the Form 2B published by the ECMC staff since the adoption of the mission change rules in January of 2021. This guidance document was phenomenal and provided much needed clarification as to the staff's interpretation of the purpose and intent of certain Form 2B sections. We hope you've had the opportunity to review this very helpful ECMC staff work product. GMT has ensured that all of the information provided to you today is one, in accordance with your expectations set at the January 8th, 2025 hearing, and two, in accordance with the staff's January 23rd, 2025 Form 2B operator guidance. The ECMC staff and CDPHE has had the opportunity to review the updated Form 2B information as it was submitted to staff last Wednesday, February 12th, and as of today, GMT has not been informed of any concerns with the updated information. GMT is very excited to hit you with the highlights as requested during our prior hearing and to present the updated Form 2B air resources and public health resources information to you today. As we just went through, the updated Form 2B, updated cumulative impacts plan, and updated dust plan were attached to the presentation as supplemental slides. They were uploaded by Ms. Gross via eForms. They were uploaded by myself via the eFilings hearing system and were provided to you by the hearings manager and were in the hearing portfolio. Again, I mention this because GMT wanted to ensure that anyone reviewing the updated information had the current version of those documents in order to avoid any confusion, since the original Form 2B had been deleted by staff. Slide 2, please, Andrea. As a quick refresher, the Secret Stash OGDP application requests that the Commission first approve an approximate 2,747 acre Secret Stash OGDP and join and spacing unit for the development of up to 20 horizontal wells for the Niobrara Formation, and second, approve the Form 2A for the Secret Stash pad. The Secret Stash oil and gas location did receive full formal approval at a public hearing by the Colorado State Land Board and does not trigger any Rule 303 ALA criteria. In fact, it is one of the least impactful proposed oil and gas locations that this commission has reviewed since the adoption of the Mission Change 2021 regulations, as its EnviroScreen score is 14.69%. Specifically, the proposed location is over 2,000 feet from residential building units, high occupancy building units, schools, and childcare centers. It's not within any high priority habitat. It's not within a disproportionately impacted community. And it's also outside of the 3,000-foot Arapahoe County 2023 setbacks. The nearest Aurora resident is located over a mile away. GMT believes this is an approvable application and respectfully requests approval of the Secret Stash OGDP application upon your review of the updated Form 2B air resources and public health resources provided to you today. With that, I'd like to turn our presentation over to Mr. Max Blair, Regulatory Manager for GMT, to continue our presentation.
Thank you, Jamie. Good morning, commissioners. Thank you for the opportunity to appear today and continue the hearing for this project. I would really like to thank you again and staff for providing the guidance that Ms. Jose mentioned. We found this information very helpful while preparing for this hearing. As you may recall, we had a very good discussion around the project on January 8th. And as we mentioned, we're here to hit the highlights and walk you through the updates we've made to the Form 2B, cumulative impacts plans, and some of our development timing. Next slide, please. So just a very, very brief overview here at the hearing. We heard from you, commissioners, that you wanted to see all 20 wells to be accounted for and modeled on a most likely development scenario, not the worst case, not the best case. And we've done that today with the information included on Form 2B. I believe you commissioners acknowledged many of the site-specific challenges and infrastructure that we discussed at the hearing. We're happy to answer questions about those items today, but I don't think we need to cover them in detail. We also expressed our efforts and desires to implement infrastructure as development progresses. This project will take some time to develop. We've been working with the local utility for electrification. We've been working on plans for an oil pipeline. And I believe, again, we discussed a number of those things in detail at the hearing on the 8th. After the hearing, ECMC published guidance on 2B input. We relied on that heavily to prepare the information before you today. Next slide, please. So let's talk a little bit about our development plan. This is a slightly different schedule than what was presented on January 8th. We are looking at potential pad construction beginning as early as the second quarter of 2025. Of course, this is dependent on ultimate permit approval first and foremost, with a drilling first occupation of drilling to occur as early as the third quarter of 2025, completions in the fourth quarter, and establishing production of those first wells in the fourth quarter of 2025. We have submitted an updated Form 2B and a supplemental data sheet as directed by the guidance published on the 23rd. We have included emissions estimates for all 20 wells and 2 drilling and completions occupations. And in the modeling, those take place about a year apart. I also just wanted to highlight that we have included some additional details in our modeling, and this is based primarily on the CDPHE best management practices. So the modeling inputs that you see on the 2B include the use of a Tier 4 or equivalent drilling rig, use of a Tier 4 frac fleet. We were able to look more closely at historic fuel usages and get a better estimate on emissions based on actual fuel usage from these types of rigs and fleets. We updated some emissions factors in our modeling to kind of current best practices in the industry. And we were able to look at the oil, gas, and water production models and ensure that they match the wells that we reference in our testimony for this hearing in this application. As was mentioned, we do intend to electrify production facilities on this site. We've been working with Excel to do so. And we have also modeled the installation of an oil gathering system after the first 12 months or so of production. Next slide, please. So I'll just walk you through very quickly how the truck trip estimates were provided in the Form 2B. The 2 lines at the bottom are what got entered into the 2B, but we've broken out the 2 occupations above that to show how these numbers come together. So in occupation 1, we've shown truck trips related to drilling on a monthly and annual basis and completions, and then initial production without the use of an oil pipeline. There will be a natural gas pipeline in place for the start of production. On the second occupation, we anticipate an oil pipeline being in place, and so there's an adjustment to the truck trips in production as a result. And then finally, the 2B inputs, that's based on staff guidance that's looking at a monthly average over those different activities and an annual average over the 20-year life of the well, which is what's shown on the Form 2B as anticipated production life. Next slide, please. I think
Max,
I apologize. I believe this is for Jamie.
That is. Thank you so much. Commissioners, the siting of the secret stash location protects public health, safety, welfare, the environment, and wildlife resources by siting outside of all sensitive receptors, and GMT has utilized numerous best management practices to avoid, minimize, and mitigate adverse cumulative impacts from its oil and gas operations. The director recommendation did recommend approval of the OGDP and conclude that the ECMC staff did not anticipate any significant potential direct adverse impacts to the public safety, welfare, environment, and wildlife resources. Further, GMT believes that the Form 2B information provided today and with our presentation continues to illustrate GMT's commitment to the responsible development of its assets. Last slide, please, Andrea. With that, GMT respectfully requests approval of the secret stash OGDP, the Form 2A, and the associated drilling and spacing unit. And we thank you very much for your time and your consideration of our request for approval today. With that, I'd like to ask the rest of the panelists to come on video for potential commissioner questions. And we can stop sharing to Andrea for now. Thank you.
All right. Thank you for the continued presentation. Commissioners, the panel is open for questions if there are any. Commissioner Messner?
Thank you. Just want to confirm a couple of things as I've reviewed the cumulative impacts plan, the Form 2B, and the presentation. The mitigation that's being proposed in the cumulative impacts plan, both in the summary as well as in the document itself, does indicate that one of the mitigation strategies would be oil pipeline takeaway. There's some discussion about that, and I want to better understand that oil pipeline takeaway and the level of commitment for that oil pipeline takeaway as it is used as a mitigation strategy in your cumulative impacts plan, as well as in your modeling for the Form 2B.
Thank you, Commissioner Messner. I'm happy to address that. And first, I'll mention that at the hearing on the 8th, we discussed this in detail as well. We are planning to construct an oil pipeline. We've done quite a bit of work to secure the rights and permissions to do so through Arapahoe County. We have an approved pipeline project that would include both oil and gas takeaway that would serve this site. The modeling for the 2B is based on the premise that an oil pipeline would be in place after approximately a year of production operations, and that subsequent drilling occupations would have oil pipeline in place to support production from those wells that come online in the future. So there are a number of other challenges that we're working through to ensure that we can deliver on that. But it is integral to our plan that an oil pipeline will be in place for the majority of the life of this well, just not for the initial production in the first year.
Okay. And then as far as the interim reclamation goes associated with the cumulative impacts plan and the Form 2B, is that timing associated with the interim reclamation, which I believe is anticipated to be completed within 6 months upon start of production, is that contemplating that happening after the second occupation?
Yes, that's correct. That's how we modeled it. That's how we indicated the traffic, and that's the plan.
And you've modeled that second occupation and the other elements associated with it being approximately a year after initial occupation. Is that correct?
That's correct. I mean, it's difficult to forecast that far out, but that's how we modeled it. That is our plan and budget. Of course, these things are subject to change, and we'll continue working to solve some of the other challenges with development that exist for all developers. But that is our plan, our budget, and our modeling are all in sync with each other, if you will.
Okay, thank you.
Further questions for the panel? Commissioner Ackerman?
Thank you. And mine are similar to Commissioner Messner's, and so I'll truncate a little bit and just ask, recognizing that, as the chair stated, that this is not part of the Lowry Cap, but it is within the geographic area of the Lowry Cap, and you've been in significant conversations with Civitas, I know. Have you had discussions about potentially partnering with them on an oil pipeline takeaway? And if so, can you talk about that a little bit?
Thank you, Commissioner Ackerman. Yes, I'm happy to discuss that. Certainly, we have been in discussions with Civitas on a number of different issues. Oil pipeline is one of them. They are the operator of the only oil infrastructure in the vicinity of this project. I'm not going to share details of those discussions, but I'd say they're progressing. They're productive conversations, and we are working diligently to perfect those discussions into an agreement that allows us access to the system.
Thanks so much. I appreciate that, recognizing that you're in those discussions still. And so thanks for sharing what you did. I as Commissioner Messner, I went down a similar road that the numbers as we asked for and appreciate you providing. Thank you for the work that you've done. We're based upon the installation of an oil takeaway pipeline in 12 months, and so it makes sense to me. And I wanted to address your level of comfort with a condition of approval that would require that installation of an oil pipeline in that 12-month period as a condition of approval.
Yeah, Commissioner, thank you for that question. I think this is a difficult question for me to answer. I may ask our attorney to weigh in on what options we have here. I will reiterate that an oil pipeline is 100% part of the plan, but the logistics of getting that in place in time are yet to be determined. As I've mentioned, and I will reiterate, the steps that have been taken that I can commit to is that our planning, the rights we've acquired from the State Land Board for pipelines include oil takeaway. The permit that we've secured with Arapahoe County, it's been conditionally approved, simply waiting on the final approval of the oil and gas pad site, which is, we believe, imminent. Also include oil pipeline infrastructure, the rights and the land entitlements to construct this line. It's also included in our long-term budget, and as I mentioned, integral to our plans. The difficulty that I have with a commitment here is related to the uncertainty that comes with relying on third-party agreements and the fruition of their plans as well that are necessary for ours to come to fruition. So with that, I think I'll ask our attorney to weigh in on what our options are with regard to this question.
Wonderful. Thank you, Mr. Blair. And Commissioner Ackerman, we appreciate this line of thinking, and we've thought about this as part of the presentation today. And the mandate for a commission or a condition of approval, I think, would be not very helpful here in this instance, where it is a committed BMP, it is a mitigation measure. There are numerous aspects that come into play when you're looking at the variables for the timing. I think one of the concerns would be if a 12-month COA is placed upon a permit, what happens if stuff outside of GMT's control, pipe, securing the pipe, things along those lines, rights of ways don't happen until month 14. There's all those issues there. But I think that, as Mr. Blair stated, there's numerous commitments and there's numerous, BMPs that cover the pipeline without having to have a condition of approval here.
Thank you, and I appreciate those clarifications, and I do understand the difficulty as these are complex operations. My kind of fallback there, as I anticipated that you might answer that way, would be, are you comfortable with a condition of approval prior to moving forward with phase 2 of this application?
Commissioner Ackerman, do you mean a condition of approval that says a pipeline prior to moving forward with phase 2?
I do. Thanks for the clarification there, Counselor.
No, Commissioner, thank you. I think, and I'm kind of looking to the screen here, but I still think there would be a level of uncomfort with that because, again, this is a planned mitigation measure. It is a best management practices. GMT wants a pipeline. I think there's a concern that what happens if that COA is put in place, but then there is a need to still transport production on that second occupation, even if it's just a month or two. So, GMT is absolutely trying to do what's right here. They are doing what's right. They want a pipeline, but that condition of approval would be a concern. And again, very respectful here. There's no requirement in the rules that there is a pipeline mandated for a location such as this. We respect your question, and I hope you can respect our answer to that.
Of course, thank you. And I thought that was respectfully presented. Thank you, Ms. Jost. And that is true that there's not a requirement on our rules to install a pipeline for this type of development. That said, as pointed out by Commissioner Messner, pretty much all of the calculations that we're using in our consideration for approval anticipate the installation of that pipeline. And so just as an operator, and understandably so, these are good answers. Understandably so, an operator has some things that may affect the potential future of the installation of that pipeline. We're approving based on the utilization of that pipeline and the assurances then that the commission needs, in order to approve this application as presented, then are not included in this application if there is no commitment to actually implement that. What we would be approving is a potential perpetual use of truck trafficking through two phases of this pipeline. So that's what would cause me the concern. But I appreciate your responses there. I think,
Mr. Ackerman, if I may, can I just add one thing? So the pipeline is a BMP on the Form 2A. The best management practice is tied to the Form 2A. And so I do think that there might be a little more teeth in there than maybe what you're thinking right now with respect to the approval of the permit without a COA. The BMPs are in there as well, and that would be part of the Form 2 that we're requesting to have you, 2A, sorry, requesting to have you approve.
Great, thanks for that addition. I appreciate that.
You're welcome.
Thanks, Mr. Chair.
Other questions of the panel? Commissioner Messner?
Yeah, Ms. Jost, I wonder if you could highlight on the 2A where this BMP is and what the exact language is.
Yeah, and Mr. Blair, Ms. Gross, I'd have to look to you for that, but I believe that the pipeline has been utilized as part of the Form 2B as well as somewhere on the 2A.
Yeah, I apologize. I will have to pull the 2A up if you bear with me for a moment. I can try to find that.
I will bear with you.
I'm looking as well, Max.
Thank you.
Pulling it up now.
And I guess the only thing I would say is that if, for part of the 2A and the 2B, again, the oil pipeline takeaway has been utilized and relied upon. So, if it's not on there as a BMP, that's my mistake. I believe it is in the cumulative impacts plan as a mitigation measure. It is also in there as part of other filings.
I'm on the 2A and I agree with Ms. Jost in that it is listed in our CI plan as a BMP, but not all of the BMPs are listed on the 2A form itself.
Yeah, and thank you, Ms. Gross. My understanding too, and Chair and Commissioner Messner, when the Form 2A is approved, that's also the approval of all of the plans attached to the form. And so, if the CI plan the CI plan does have the mitigation measure best management practice of pipeline, that would be part of the approval of the Form 2A.
It's just, maybe I'm dense, but if the pipeline is a commitment as a best management practice on the 2A, how is that any different than a pipeline being a requirement as a COA? Both are binding. Or am I missing something, or are we misinterpreting how your client approaches this?
No, Chair. Thank you for the question. And you're not. A COA, I think, just yes, we've always looked at it as a COA is similar to a BMP, but a COA is a voluntary point that's put on the Form 2A, whereas a BMP is something that has been submitted to as part of the plan and part of the 2A. So again, to me, I'm not explaining this very well right now, but there's not a lot of difference because with the BMPs that are included on the Form 2A, as well as in your plans, are still approved as part of a permit. And so from the standpoint of having it be a condition of approval, one, I think that would kind of set a new precedent, but secondarily, it also is something that could just be looked at as something that may have to change in the future. And if a condition of approval has to change in the future, I think that's a little bit different than having a BMP change in the future under a sundry.
Commissioner Ackerman?
Thank you, and I appreciate this discussion, and thank you once again for facilitating it. I do note as we were looking through the 2A there that on the bottom of page 11 of the 2A, it does say, and I take this as a commitment, for the first occupation, oil and water will be trucked off location. The implication of that is that for the second location, that would not be permissible. Is that what we're talking about here?
Ms. Jost?
Mr. Blair, is that something you can answer?
I believe I can, but Commissioner Ackerman, if you would, can you give me the page reference again? I apologize. I do have the 2A up on my screen now.
Sure, you bet. I just have it on page 11 under operator comments and submittal. Second line down states there's not a water or oil pipeline in the area currently. For the first occupation, oil and water will be trucked off location.
Yes, that is the plan, and as I've mentioned, the plan and many efforts have gone into securing an oil pipeline for the second occupation. Again, my concern with the condition of approval, as Jamie has mentioned, is simply the uncertainty that we are dependent on some forces outside of our control, third party agreements, and the build out of infrastructure. So as far as a condition of approval from the commission at this hearing, ultimately you will decide the motion and the vote. Our request is that you not make it a condition of approval that an oil pipeline be required, but that is our intent, and we are doing everything we can to secure all the components to ensure it's in place for that second occupation.
Yeah, and Mr. Blair, Chair, if I may add just one more thing, this is where in preparation for the hearing today, we went back, we looked at everything that the commissioner said at our January 8th hearing. We actually got a transcript and had it verbatim, word for word. That the ask was for most likely development, and that most likely development includes a pipeline. And so that was expectations set by commissioners. That was carried through in the Form 2B guidance. Again, that was a wonderful guidance. And so that's what's been presented, with the most likely development including the pipeline. And GMT wants a pipeline. They have planned for a pipeline. As Max said, the timing, the planning, the budget allows for that. It really just comes down to the concern of having a COA put on for a pipeline versus any concerns with it moving forward, because that is the intent. And that's what the ask was, most likely development.
Thanks for all that. AG Mercer, could you weigh in on the issue that has been identified, which is that there's a BMP that contemplates a pipeline for phase 2, but there's a concern about a COA that contemplates a pipeline for phase 2. I guess in my mind, I don't know that I agree with the implication that a COA is a voluntary commitment. I think it could be that, but I also think if it's necessary, as the commission determines, that an element be there to meet our rules, then it's a commission enforceable part of the application or part of the approval. But if you could weigh in on that distinction, I would love to hear from you.
Thank you, Mr. Chair. I'd be happy to. So I agree with a lot of what has been said here by both yourself and Ms. Jost. So as a threshold issue, BMPs, best management practices, and COAs, conditions of approval, are quite similar in my mind. They, as you point out, are both binding permit conditions. Whether an item is in an application as a BMP or a COA, an operator is bound to comply with it. And if they don't, they could face enforcement consequences or other actions. The way that I've typically looked at this, and the way I think we've looked at it as a commission and staff, is that BMPs on an application are voluntary measures that the operator proposes and agrees to. And then conditions of approval, we've used that as to really characterize something, an action that is not voluntarily agreed to by the operator, but rather is imposed by the commission over over the operator's objection or non-agreement. Once they're on there, like I said, they're both binding. I would also say our practice has been that all BMPs, so just like Ms. Joe said, all BMPs in the application materials are binding. All of the plans that are submitted as part of an OGDP become part of that permit and part of the legal document governing the operations and what's approved. So something is required if it's in the cumulative impacts plan, the wildlife mitigation plan, et cetera. Those are all binding parts of the permit. It has been our practice to ask that all BMPs in an application be listed on the Form 2A because the Form 2A is sort of the major governing document that folks look to see what's required, whether those folks are the operator, the public, enforcement staff, et cetera. So particularly with a BMP that is the commission assigns a lot of importance to, I would advise that it be added to the Form 2A. Like Ms. Joe said, there's not really a difference in terms of whether an operator is committing to it if it's in a plan versus the Form 2A, but administratively it's the proper process, I believe, for it to be reflected on the 2A as well. Happy to take questions. All of that is to say that if the operator is committing to oil pipeline, I believe we're only talking about oil takeaway, not produced water. If the operator is committing in some fashion of a BMP to oil takeaway by pipeline prior to the second occupation, it is my advice that that should be added to the Form 2A as a BMP.
All right, thanks for that explanation. Commissioners, does anyone have questions of Ms. Mercer? Does anyone want to move into deliberative thoughts? And I'm also not suggesting we may be done with questions, but I think we've kind of exhausted the area of issue here.
Mr. Chair, may I add one thing just really quick?
Yeah, I'm sorry, I didn't see you. Go ahead, Ms. Jost.
Okay, no worries. Thank you. I know there's a lot of folks on the screen. So from GMT's perspective, based on what Ms. Mercer-Gelman just said, we will gladly add the BMP to the Form 2A so it is clear. It's in the plan, but we will gladly add it to the Form 2A so we can follow what Ms. Mercer-Gelman was stating, specifically from the administrative side.
All right, thank you for that. Commissioner Ackerman?
Sorry, can you just specify exactly what that BMP added would be?
Yes, and Mr. Blair, please correct me if I say it wrong, but that the BMP, the commitment to the oil pipeline for production for the second occupation that's in the cumulative impacts plan, that BMP will be added directly to the Form 2A, so it tracks the same language. So instead of a COA, it's just the BMP that is clearly stated on the Form 2A, the same BMP that's stated in the cumulative impacts plan regarding oil pipeline takeaway.
Okay, so with that, we've got a commitment from the operator or an understanding from the operator that if approved, the approval will be, there will be a requirement for an oil pipeline takeaway as part of phase 2. Is that right, Ms. Jost?
That is correct.
Okay. Commissioners Messner and Ackerman both raised their hand before I rudely interrupted them. So either one of you can go forward with whatever question you may have had.
You fixed my clarification. Thank you, Mr. Chair.
Commissioner Messner?
Yeah, I guess it's not much of a question. I don't think that the cumulative impacts plan that at least that I've read, unless someone can point it out to me, is that specific as far as the oil pipeline goes. And so I've reviewed that, and it just indicates that one of the mitigation strategies would be an oil pipeline, and that's the extent of it, unless I'm missing something.
Thank you, Commissioner Messner. I mean, I think that I don't have the CI plan in front of me, and I would look to Mr. Blair or Ms. Gross if they have it. But what was just stated, both to Chair Robbins and in response to Commissioner Ackerman's questions, will be that there would be oil pipeline takeaway prior to production from the second occupation as a BMP. On the Form 2A. My apologies.
All right, very good. Further deliberative thoughts, Commissioner Cross?
Thank you, Mr. Chair. And I want to ask sort of an unrelated question, and I think I raised this during the last hearing as well, but wanted to try and see if there was additional information. In other presentations that have come before us, I know that Renegade Oil and Gas has talked about working with GMT to try and identify potential collaboration on natural gas takeaway. And I was wondering if you had any statements about that, if you're working with Renegade or others on the gas takeaway as well, which I know you have said will be part of the secret stash before production, but was curious about that.
Thank you, Commissioner Cross. I appreciate the question. I think I'm going to ask our land manager, Hans Schuster, to weigh in on any discussions that have taken place between the two parties.
Yeah, thanks, Max. Similar to the Civitas oil pipeline situation, we're in constant communications with all our neighbors to help find efficiencies in the field. And so we've certainly had discussions with our neighbors, which Renegade is one of them, but we have no concrete plans at this point to install any additional pipelines. Similar to, again, the Civitas conversation, those conversations are ongoing, and if they materialize and kind of make sense, we're definitely not against it.
Thank you for that. Again, not necessarily contingent upon this, but I know it's something that has come up in other situations, so I just wanted to try and inquire further.
All right, further discussions, deliberations? Commissioner Messner?
Just a point of order. Are we going into deliberations, or is this deliberations?
I think I guess I was not quite accurate. Does anybody have any other questions for the panel? And if not, then we'll unvisualize the panel and the commission will have themselves to deliberate. All right, panelists, thank you for your time. Please unvisualize, if that's a word, and we'll leave it to the commissioners for deliberations. Commissioner Messner?
Thanks, Mr. Chair. Happy to start. I am going to be a little bit all over the place. Ultimately, I think our job here is to apply the rules that have been promulgated based on both the act direction from statute and, with the studies and data and information that was, analyzed and developed through the mission change rulemaking. I think that as we've indicated at the last hearing, from a siting perspective, there's a lot of benefits to this site. I think that there's significant distance over 3,000 feet from any existing RVUs, over a mile away from high occupancy building units and schools. I think it's not in a high priority habitat. There's a lot of elements that I think are beneficial in this area. I also think that this is an area that has significant dense residential development within the vicinity, and I think that the reasonably anticipated future development of the trails of Overland Ranch do need to be part of our consideration and looking at the overall cumulative impacts of oil and gas development in this particular area. I think that, based on the review from staff and the consultations from CDPHE, there's been a number of BMPs that have been suggested that have been accepted by the operator, and I appreciate that. I do have concerns about truck trips associated with oil takeaway. And I think that's reasonably, a reasonable consideration of this application, understanding the level of density of some of the subdivisions within the vicinity. And so, looking at this overall from a cumulative impact standpoint, I do appreciate that the update that the operator has done on this and approached it, I think, in a more organized and clear fashion with their cumulative impacts plan. It was clear to me what they were looking at and what they were evaluating from a cumulative impact standpoint. And I think it was, as I read it, I thought it was clear what they were proposing. And what I had read was oil takeaway within 12 months of production and electrification of the site, which I thought was reasonable and necessary for evaluating and addressing cumulative impacts in this application. Now, at hearing here, that's become a little bit confused, I think. And so I would be comfortable with this application with a condition of approval of oil takeaway within 12 months of production and electrification, as at least I contemplated within the cumulative impacts plan that was proposed, as well as was contemplated in the cumulative, the Form 2B from a modeling standpoint. I think that's reasonable and necessary for addressing cumulative impacts associated with the density of subdivisions that may be in the vicinity that could be impacted by the truck traffic associated with hauling oil for any significant amount of time. Understanding that in lieu of that, they would be allowed, because there's no clear commitment to when that second occupation would be. Without that COA, they could be hauling oil for years prior to any second occupation. And I don't think that's what the cumulative impacts plan contemplates. And I think the potential for significant changes in the surrounding areas, over the years is real. So my suggestion would be approval of the application with those two conditions of approval, but I'm certainly open to thoughts from other commissioners.
Thanks for kicking us off. Other commissioners with thoughts? Commissioner Ackerman?
Thank you, Commissioner Messner. Thanks, Mr. Chair, and thanks for the discussion here today. I also wanted to thank the operator for the additional work done pursuant to the continuance. There's a lot of work done on these in Colorado, and particularly by operators and by staff, but also by members of the public whose comments today significantly demonstrated that they've become educated on these issues and have dived into the specifics. And for me, that public engagement is very important as a commissioner in helping to make these difficult decisions. The statutory and regulatory starting point in Colorado is very strong in oil and gas development. It's based on regulations stemming from the Mission Change Rulemaking and Senate Bill 19-181. And those regulations took the better part of a year to establish, and they included significant public discourse, significant scientific scrutiny, and significant public input, and are widely considered to be the most protective in the nation. I do keep that in mind as our starting point, and I applaud operators that move forward in working within the confines of those regulations. And I do recognize, as stated earlier by Councillor Jost, that we often ask for things that may go beyond the specifics of what are associated with those regulations. Generally ask for those in a voluntary manner. In some cases, we do place conditions of approval that we deem necessary in order for an application to go forward. As I mentioned in my comments, the data in the application was based upon the mitigative strategy of having an oil takeaway pipeline in place after 12 months. So all the data stemmed from that assumption. And it does make sense to me to ensure that that protection's in place in a reasonably timely manner in order to ensure that this application is actually consistent in its execution with the application materials. And I appreciate, Mr. Chair, you clarifying my understanding of the commitment from the operator during this discussion is that added to the Form 2A will be a commitment for oil pipeline takeaway, at least prior to phase 2. I also am in favor of Commissioner Messner's proposal that I do think a 12-month commitment is appropriate because of the initial presentation's uncertainty in ever moving past phase 1. I don't want to go down that rabbit hole, but I still remain some degree of uncertain as to what the provability of this relatively proven reservoir will be as it's on the south end of the Niobrara. The testimony, I believe, from the operator was that they have significant confidence in the productivity of this reservoir at this place. Certainly, an alternative to what Commissioner Messner has suggested would be to approve phase 1 and then require the operator to return back to the commission with application materials that accurately describe the mitigative methods and commitments to be used during phase 2. I prefer the former approach. That said, I am in support of this application moving forward with the COAs as mentioned by Commissioner Messner. I think that there are significant benefits to the location of this application and would be in favor of it moving forward with those COAs. Thanks.
Further deliberative thoughts? Commissioner Cross?
Thank you, Mr. Chair, and thank you, Commissioners Messner and Ackerman for leading off on that. I'll be honest, I'm sort of still trying to process and put together some thoughts with respect to a 12-month COA as opposed to a BMP requiring oil takeaway via pipeline before phase 2 would commit. I think consistent with what Commissioner Ackerman just said, I too would be more in favor of approving the OGDP as presented as opposed to requiring GMT to come back a second time for what we're calling phase 2 of this second occupation with respect to the application. I'll start off saying and this was discussed during the previous hearing as well, I do think that this is a good location. As was highlighted during the previous presentation, as well as during this presentation again today, we're looking at an area where the enviro screen score is very low. It's far from residents, it's far from schools, it's not in a disproportionately impacted community, not in high priority habitat. There's a lot of really good things about this location. And like my fellow commissioners, I appreciate the hard work that went into updating the information that we requested during the previous hearing. I will say, both for GMT and for future applicants as well, I think it's important that this information be completed the first time around in future endeavors coming before us. I think that a lot of the uncertainty that comes with what we saw in public comment today comes from the fact that we didn't have a clear picture in what we initially saw here. While I think it is a good location, what we initially saw was something that said, well, this may be 2 to 6 wells, it may be 20 wells eventually, it may happen in multiple occupations. We're not sure how many occupations that might be. It was really unclear. It makes it very hard for us to estimate. Not that what was proposed was contrary to what the regulations require or mandate, but I hope that operators can see that that kind of uncertainty, that kind of, I don't want to call it ill-prepared, but this kind of uncertainty on what's being proposed for us makes it hard for us to understand that what we are considering to approve or not. So I do appreciate the work that was put into it to make sure that we understand what the actual number of occupations will be, what the actual processes will be in terms of, as talked about, a BMP and now the consideration of the COA as well for the oil pipeline takeaway and what the overall numbers will be once that pipeline is put into place. So I will start off saying that I am in favor of approving this application. Again, I think it is a good location. And I'll be honest, I'm gonna stop there, and I'm still trying to think about a potential 12-month COA as opposed to the BMP, just requiring the pipeline takeaway before the second occupation.
And I want to start my part of the deliberation with, again, looking at it overall, I believe this is very approvable. And for all the reasons that we talked about at the beginning. This issue about the pipeline, correct me if I'm wrong, commissioners, but did the new Form 2B, I thought it was derived based upon the concept of the 12 months of production. And I think that's where Commissioner Messner got that idea. Is that accurate to you guys? Commissioner Messner, you're always on top of the details.
So the cumulative impacts plan does address or does look at that, right? So the modeling that was done around it, at least based on the information that was provided, appears to indicate that the modeling is based on oil takeaway within 12 months after production and electrification of the production facilities. The initial, but then if you look at the Form 2B itself, there's certain truck trips that are contemplated that are without pipeline. And then there's other truck trips that are contemplated with the pipeline. And so it's not completely clear, but I went into it as I read it overall with the assumption that the modeling was done based on 12 oil takeaway within 12 months, or 12 months after production, I'm sorry, and then electrification of production facilities. And that's where I based my evaluation of it. And if as I look at it through that lens, I do think it meets our rules and fully evaluates and addresses cumulative impacts. Without that, I'm not sure.
Commissioner Ackerman?
Thanks, Mr. Chair, and thanks for raising that. Yeah, and also in CDPHE's review, they note that GMT's plans are originally were to drill 2 wells, potentially followed 12 to 24 months later is what the original application said by additional wells. And so coupling that together with what Commissioner Messner has talked about in the cumulative impacts plan, helped me coalesce, and together with today's presentation, helped me coalesce around the 12 months. And part of the difficulty for me of the distinction here of 12 months as opposed to prior to phase 2, many of the applications that we see, have phases, and their phase is certain, and they're going from phase 1 to phase 2 in a certain degree of time. This application to me is stuck somewhere between an exploratory development and a full development. And that, I think that's what's caused a great deal of confusion for me. And so in the end, if we commit to prior to phase 2, that's good, I think. And I think that today's discussion has already committed to that. That said, without there being a phase 2 certain, what that could mean to me is truck traffic for these wells for their entire life, as approved in that way, if they never do move to phase 2. And so hence my preference for a 12-month commitment, and I would be open maybe even to some negotiating room there, as far as establishment of an oil pipeline, once again, because that's what the application materials were based from.
Commissioner Ackerman, is it true that the phase 1 versus phase 2, that we really don't have a definitive understanding of what phase 1 might be comprised of versus phase 2? Is that kind of the line that you were going down?
I think so, and particularly the timeline of phase 2 associated with phase 1, or even the eventual existence of a phase 2, based upon productivity of these wells, as per our initial discussion on the 8th of January.
Ms. Jost, did you want to uh, provide context here?
I do. And Chair, thank you. I know this is a little out of order on my end, but in listening to the deliberations, I guess just a couple things I'd like to provide. From GMT's perspective, I just want to make sure, sorry, I'm pulling up the language, that, based upon what's been stated here and some of the concern and, looks to be confusion over the commitments, GMT would accept a COA that GMT will commit to installing an oil pipeline to take production from wells drilled under a second occupation. That is a COA that would be acceptable to GMT. The 12 months, just for clarification, that's based upon the Form 2B's requirement that states this table should be filled out based on 1 year of operation for air emissions. So that 12 months actually stems from the Form 2B. Just for clarification purposes. So if the commissioners would be open to the COA that I mentioned, GMT would be open to putting that on their permit. Thank you, Chair, for the allowance.
Yeah, certainly. With that, further deliberative thoughts from folks? Commissioner Messner?
Thanks, Mr. Chair. I don't know if I've had further deliberative thoughts. I mean, the mitigations that were included in the cumulative impacts plan contemplated the 12 months, the pipeline after 12 months of production and the associated truck trips and the potential impacts that extend further away from the site associated with that intensity of truck traffic, particularly with that number of wells and that length of lateral development, and the reasonably known future development density that's associated with some of the development in the area. And so I still read the cumulative impacts plan as contemplating the 12 months after production, the development of an oil pipeline. And so I would be most comfortable with that COA as I initially proposed.
Great. Thanks for that. And Commissioner Ackerman, it sounds like you're in a similar place. Is that right?
That's true. Thank you.
And Commissioner Cross, it sounds like you're in a different place looking at the phase 2 for the pipeline. Is that accurate? I'm just trying to poll folks.
Yeah, I think I am, Chair, and I agree that it was talked about in the cumulative impacts plan, and I guess I'm just viewing it a little bit differently. I recognize that is a minimization measure discussed in the cumulative impacts plan, but I don't know that if a phase 2 was never to happen, I don't know that, especially as production will decrease over. I think it even was shown during today, and what we've seen previously is the peak number of trips is actually going to be in, I think it's going to be months 2 to 6 or something like that is likely, and it's the same thing with produced water. And so I think I'm less hung up on there not being protections necessary. I think that some of the minimization that would occur with an additional one is what's being contemplated, is the way I look at the cumulative impacts plan. And so I think I'm more of the view that if a phase 2 was to happen, I think it's important to have the additional minimization measure with the oil impacts through a pipeline than just the first, because partly I think as well that if there's only going to be one occupation, it likely means there's not going to be the production that they're anticipating. And therefore, we're probably not going to see a great number of trips anyway. And so I think that what we're seeing in the 2B is an estimate of projected annual truck trips based off of no pipeline. And so I think we do have an understanding of what the impacts are from that. And I more so see the minimization occurring for a second impact or a second occupation, excuse me.
Yeah, I think I agree, Commissioner Cross. And I think this gets to a little bit of some of the direction that we gave last time about the 2B dealing with the quote, most likely, end quote, development. as opposed to, what is the committed development. And so we've not voted yet, but we only have four of us. And at this point, it appears we're split, which means we can't actually approve anything. And so I'm AG Mercer Gelman. I know this is your last rodeo as our lawyer, but do I have that right? If we've got two that are looking at pipeline before the second phase and two that are looking at pipeline for the 12 months of production, then we're in a stalemate?
Yes, Mr. Chair, that's correct. Any motion needs a majority vote to pass. So if any motion would be 2 versus 2, nothing would be able to pass.
And then procedurally, we would continue this to a time frame in which we could have all five of us. And then we would mandate that Commissioner Oath listen to this recording, and then she could come in and figure out what her direction is.
Yes, I think that's a good path forward.
I don't see a different path forward. I don't know that we necessarily need to go through the motion second defeat to get to that point. Let's take 5 and come back at 11:50 and give folks just one last chance to sort of look at their notes. All right, we're back on the record. Appreciate you showing up, Ms. Jost, because I've got a question for the applicant. I think the applicant can see where we're at, and we're at this unfortunate crossroads of only having 4 commissioners. I do, I'm still in the place that I was. I think Commissioner Cross is, and I think Commissioners Messer and Ackerman are in a slightly different place. Happy to continue this to a time in which Commissioner Oath could get up to speed, and then we could come back in and give you an opportunity to argue your piece, and we'll see where that goes with the full commission. Also, could be comfortable if the applicant would be amenable to a condition of approval that speaks to the 12 months, that we could get this approved today, because I think otherwise it is approvable. So I'm not trying to suggest one way or another, but I would be remiss if I didn't ask you to speak to your client and, consider the different pathways forward, because they're pretty obvious.
Yes, thank you, Chair. So I guess a couple things, and again, commissioners, we recognize this is seemingly kind of a case of first impression yet again for GMT. And from the standpoint of just maybe some clarifications again, I just want to talk about the 12 months piece. That 12 months is a modeling piece that comes from the Form 2B. That 2B is very clear that the table has to be filled out on a 12-month of operation, and it's an estimate. That's modeling. That's the most likely. So from that standpoint, again, GMT would reiterate that it can commit to installing another pipe or an oil pipeline to take production for the wells drilled under second occupation. The 12 months is concerning, but Chair, with that, we would rather have a continuance than have a concern today or a vote today, and we'd like Commissioner Oath to be able to weigh in on this. I think that we would like it to be next week, if that's enough time, or maybe the week after. But as we continue to progress this, the 12 months is concerning, because again, that is a modeling time frame. Negotiations are confidential. We can't really go into some of this infrastructure components. But again, the commitment is there. And so, from Commissioner Messner and Commissioner Ackerman, I don't know if you'd have the ability to really reconsider GMT's request for not having 12 months in, but the full commitment to oil pipeline takeaway for any wells drilled on a second occupation. Just maybe reiterate that request today, but then Chair, if not, we'd gladly take a continuance on this so Commissioner Oath could weigh in.
Commissioner Messner?
Thanks, Mr. Chair. Thank you for your thoughts, Ms. Jost. I think it's important to bifurcate the Form 2B and the cumulative impacts plan, because those are two completely different things. The Form 2B is a data gathering form associated with the CIDR database, and the cumulative impacts plan is a plan that per Rule 304C19 is required in order for an operator to make a showing on how they evaluate and address cumulative impacts. The pipeline takeaway associated, at least the way I read it in the cumulative impacts plan, the pipeline takeaway comported with that 12 months. It also was not specific on that anyway, and so I maybe made an assumption in there, but as I evaluate that cumulative impacts plan and how it evaluates and addresses the cumulative impacts that have been identified as part of that cumulative impacts plan, and also how it comports with the requirements of Rule 304C19, and finally how it applies the mitigation hierarchy, where the mitigation strategies that are identified inside the Rule 304C19 cumulative impacts plan identifies oil takeaway as one of the mitigation strategies. And so as I looked at that and evaluated the cumulative impacts plan, I was okay with it being 12 months after production as an opportunity to get those negotiations done. It could also be read that the oil takeaway was contemplated in the cumulative impacts plan immediately. And so I looked at those two things and assumed that the operator was proposing the 12 months after production based on both the cumulative impacts plan, the Form 2B, and the presentation that was given as part of the packet as well. And so that's where I landed. These are two different things, two different rule requirements. 304C19 cumulative impacts plan is different than the Form 2B. And so this is an opportunity for the operator to make a showing on how they've evaluated and addressed cumulative impacts and applied the mitigation hierarchy. The challenge with the lack of commitment for the second occupation and having a BMP or a COA associated with some unknown timeline is that it doesn't adequately evaluate and address cumulative impacts because there's no certainty in order for being able to evaluate that. And so I think that the 12 months after production is reasonable. I think it was contemplated. And I think that's still where I land.
Commissioner Ackerman?
Thank you. I can't say it better than Commissioner Messner just did, but the bottom line, what it comes down to is, to me, and I think the points made by Commissioners Cross and Robbins were excellent points and agree with them. The bottom line for me is that this avenue, if approved under the BMPS as proposed by the operator, does leave open an opportunity for the trucking of fluids for 2 to 6 wells in perpetuity. And I don't think that's in line with the cumulative impacts plan, as Commissioner Messner has stated. And so that's my concern. If there's a way other than what we've proposed to assure that that we've closed that loop and there's not a potential for perpetual trucking of those wells, I'm open to it. But this is the best approach I can think
of. Okay. With that, I would move to continue the application. Ms. Jost, I recognize your desire to have this next week. Ms. Oath is out of office all week, and I get concerned that she may not have the capacity to get up to speed, and I do think you want her up to speed. So next week's too early. The following week, I am at a conference and I am not going to be available. And so you'd end up with a similar kind of concern. The first week in which all 5 of us would be available and to give Commissioner Oath an opportunity to get up to speed is, I believe, March 12th. Hearings Manager Thomas, are you with me?
Yes.
Does that sound about right?
Yes, and March 12th is open.
Okay, so I would move this application to March 12th.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? All right, motion carries. Appreciate you and your client continuing with us as we try to get to a place in which the full commission can make the right decision for this application. So thank you.
Yeah, thank you. Thank you all for your time today.
All right, commissioners, we have concluded the business of today. Move to adjourn.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? We're adjourned. See you next week. Oh, and next week we've got high priority as well as I think produced water. So it's going to be a big week. So be ready. Thanks.